The Cannabis Conversation. A European perspective on the emerging legal cannabis industry.
Welcome to the Cannabis Conversation with Anuj Desai, where we explore the new legal cannabis industry by speaking to the professionals that are helping to shape it. On today's show, I've got Jane Hollywood and Rob Stephen. Jane is a senior patent attorney and Rob is a partner at CMS, which is a city law firm in London, but also has offices all around the world. We are going to be talking about intellectual property today and how it intersects with cannabis and the various developments going on in that emerging sector. Welcome, guys.
Thanks very much.
Thanks very much, Nij.
Pleasure. So I've got you on here to give us a kind of 101 on intellectual property. I'm sure lots of people are looking at it and thinking about it and talking about it in relation to cannabis, but maybe we'll start with taking a step back and maybe just explaining what exactly is intellectual property.
That's a good idea. It's basically something that you create with your mind. So that could be a story, it's often an invention in our field, or an artistic work, or a symbol, basically something that a person thinks of.
Great. And what sort of types of intellectual property are there?
There are a number of different types, dependent on the type of work that you want to protect, and some of those are registered rights and some of them are unregistered rights. One of the main rights is patents, and that's the area that Rob and I are mostly involved in as patent attorneys. Patents are, of course, registered rights. They are intended to protect technical innovations. So that's a new solution to a technical problem. So just to try and maybe provide some examples of that. If you had just a simple example, a car, and you found a way of making it go faster, or you found a way of making it more economical, then whatever you did in order to achieve that sort of technical solution is potentially patentable. If you, though, changed the shape in order to make it look nicer, but there was no sort of technical result from that, then that's not appropriate for patent protection. Another type of right is plant variety rights. That's a particular right that can be used for a new and distinct plant variety. It's sort of related to patents in a way, but has been developed, I think, as a compromise because of farmers' fears of patent rights stopping them using plant resources in order to breed plants and make new varieties. So it's a sort of additional right to that. Trademarks are another significant right. Trademarks are most people are familiar with. That's generally used as a badge of origin so that you can connect a particular service or product with the trader that is distributing that product. Also design rights, quite common. You can get unregistered design rights and also registered. And another significant area is also trade secrets, which you hear less about because, of course, they're not registered. And those are used for confidential information that gives competitors some sort of advantage in the field they're operating. And then finally, there's also copyright, which is a well-known unregistered right that arises automatically for literature and artistic works.
The distinction between registered and unregistered, I guess, is probably very obvious, but registered, you have to go through an application process to register it with an independent body.
Exactly, that's right. And so depending on the right, it has different requirements that you have to meet in order to get successful registration. But yes, that's exactly right.
Yeah. And actually you can go and look on the register often. So you can then search for stuff because it's publicly available, and that's quite useful.
Yeah.
Whereas copyright, which is an unregistered right, just comes into existence when you create a work, and so it's not registered, you can't find it.
Yeah.
So different kind of access to information things appear for us.
Yes, a lot more of a grey area, I suppose, in terms of... Yeah, sorry, go on.
No, I was going to say, no, exactly, it is more of a grey area, and so often, a registered right is generally a stronger right because you can see exactly what it is.
And you pay for it.
Yes.
But not infallible, as we'll go on to speak
exactly,
about, I'm sure.
Absolutely.
Great, cool, thank you. That's a good rundown on a high level of what intellectual property are and a few of the types of rights involved. What sort of protection does intellectual property rights offer?
So there are a number of different types of protection. Actually depends a bit on the right that you're talking about. I think, first of all, it's probably worth flagging that that these rights tend to be national rights. So you don't have a world patent. You'll have a GB UK patent or a French patent, for example. And there may be some EU rights, but generally you need to think about geographical territory. And actually they also differ in terms of what's available in each country. So in Germany you can get a lower grade of patent protection called the utility model. In the UK you can't. So you need to kind of think about where you are geographically and what's available to you. So that will differ.
And is there any kind of international agreement to recognise each other's patents, or is it all every man for themselves?
No, there are all sorts of agreements to recognise certain aspects of the process that we probably won't go into, like the ability to claim priority. There's a bit of history around that.
Right.
I think in our world you have a year's grace period to file a patent application and then claim the same date anywhere around the world. And I was always told that was to do with the time it took to ship out your invention on a ship, literally 400 years ago, and get it to China and point out that a year ago you did do something.
Right.
So some of these things are in history, but there are a number of international agreements, and actually fights around IP rights and recognising similar rights come up in a lot of trade agreements. I think with the US and China at the moment as well. So a subject for dispute.
Yes.
It's fair to say that once rights are granted, and certainly in the field of patents, there's no recognition. I mean, they're very much national rights.
Right. So you have to then go and apply in all territories you want to.
Exactly. So,
and they'll be enforced differently and have different scopes and different aspects of national law will apply. So you will always end up using a local representative in the US or China to enforce whatever right you have or to advise you on it.
I mean, even within the EU, where there's supposed to be an element of harmonisation of laws, you can get the same patent, which is enforced in a number of different European countries, having the same patent fight, and you get different results because of the way the law is interpreted by different courts. So
the lawyers are the winners at the end of the day.
So the lawyers can be the winners. And then you have different durations of protection. So if you have a trademark, that can, in theory, go on forever, as long as you pay your fees, whereas a patent will run out at some point, 20 years from filing. And then the idea is that opens up that technology for anyone to be able to use. So different scope of protection, different geographical considerations, and also different aspects of infringement, really. So if I have copyright work, to prove infringement, I need to prove copying. Someone actually has to copy that work. Whereas for a patent, which is more to do with copyright is the expression of an idea, but a patent will protect the idea expressed in a number of different ways. So I don't have to show copying. I just have to show that you're using my monopoly. So those are interesting. And I think also probably an important point from maybe this discussion is that a patent gives me the right to stop you doing my patented invention, but it doesn't give me the right to do it. So it's a right to exclude. It is not the right to practice.
Right.
So for example, if I get a patent on a cannabis product, that doesn't mean to say that I can sell it. It means to say that I can stop someone else doing that.
Right.
So that is quite a common thing that people struggle with a little bit.
Right. So as in people would register a patent just to stop other people from...
Well, I've seen people say, I have a patent and therefore I can sell. And the answer to that is no. You have a patent, you can stop someone else from selling, but that doesn't mean to say that you can sell, because it might be illegal to do what you're planning to
Understood. Yes.
So there's an interesting difference there in what a patent actually gives you.
Sure. Wow, there's loads there, isn't there? So I guess to recap, a patent, which is obviously your sort of speciality area, is almost like a reward for the research and the money you spend in developing a certain product or a technique or a process. Yeah. And it gives you a monopoly period in which to exploit what you've created to the exclusion of all others.
Yeah. And that's right. And then the theory goes, if it takes me some millions to make that investment and make that advance, would I have done that if, as soon as I've done it, someone else can copy it?
Absolutely. And I think the other thing to take into account is it's sort of it's a bargain with the state, in that if you're going to be granted this monopoly for 20 years as the maximum it can be granted, you have to disclose the information, because you have to, in a patent application, you have to include enough information for another person to be able to practice the invention. And 18 months after you've filed your patent application, it's published. So it's a sort of, okay, if you're going to get this monopoly, then you're going to have to make what you're doing totally public. So that's in sort of contrast, right, as the trade secrets, which some companies will use because there's no time limit. So if you can keep it secret, that in some ways can be more powerful, right, depending obviously on the specifics of what you're talking about.
Sure.
So that maybe doesn't work if you're selling something and it's reverse engineerable, and I can go and work out exactly what it is, then there's no point in keeping it secret.
Yeah. I think Coca-Cola is the sort of well-known example of a trade secret where their recipe has never been revealed.
KFC, I'm
KFC,
sure.
Exactly.
Shows my level, really. Cool. I guess where does this intersect with cannabis?
I think everywhere, basically. I think all the rights are relevant to the cannabis industry, and there's so many different sort of aspects, obviously, of the cannabis industry that where they come into play. We have seen lots of activity on patenting, certainly trademarks, plant variety rights, of course, and also design rights. And then, of course, you won't see the activity on the trade secret front, but I understand that things like parent breeding strains of cannabis plants may well be kept as a trade secret. So, I mean, wide use of these rights for the...
So maybe we start with probably, let's work towards the plant, but the kind of the easier things to understand. Branding and trademarks are probably some very obvious ones,
Absolutely.
particularly if you've got consumer-facing brand.
Right, exactly.
Yeah, I think with branding is significant probably to almost all companies operating in the sector, and particularly important to companies in busy consumer areas like the CBD area. And then for branding, of course, you'd be looking at trademark registration generally, but also design rights can come into play, perhaps with your packaging or logo, copyright as well. So that's really important for companies to get that right, which is the same, of course, in all sectors.
Yeah, and I think it is probably quite important here because there are so many similar sounding products on the market.
Yeah, that's true. Yeah, absolutely.
And so it could be easy to cash in if someone hadn't protected themselves of someone else's reputation.
Yeah.
Yeah, and you can have disputes between similar sounding brand names for similar products, and then lawyers get involved.
Absolutely. So, and I guess as well, also in particular in the CBD field, you see just, in the newspapers, discussions of whether products, what sort of quality products are, etc. And so then it's also extremely important to have your brand associating you with the right products.
Sure. Okay, cool. That one's fairly easy to understand. Formulation was another one that I was thinking about. So people are trying to sort of differentiate and put different things together to provide products to consumers. Are you seeing protection in how people are formulating products?
Certainly patent protection is potentially available to formulations, and that's something that we see in the life science field a lot. So medicinal cannabis, certainly formulations where you have some sort of medical effect. So you could, of course, be, if it's treating a new disease, that's a clear one, but also you could perhaps have a better formulation where you have, sustained release of a particular type of drug.
Right.
That sort of formulation certainly could potentially be patentable. Perhaps it's more difficult. I'm just thinking of sort of levels of purity, perhaps for CB more on the sort of consumer front.
So GW Pharma products are
So they're medical formulations. So those, I think, potentially that sort of thing can have patent protection. Other formulations where you don't have a sort of a medical effect, that's more tricky. I'm not sure
how the patent office would respond to that if you say that if you couldn't demonstrate a technical improvement, which is what we're a bit obsessed about as patent attorneys, is are we achieving something better, quicker, faster here?
Right.
If you're not demonstrating any of that, then the patent office may well have a problem with it. Yeah. If I'm just putting a blue gel with it rather than the pink gel, what's that doing?
Yes.
So it may look nice if you like pink, but it's not doing anything to improve the product.
Yes.
So
in that case, you may want to be relying on whether you can keep exactly your formulation secret if it's particularly popular, or I don't know. Maybe that's a brand protection thing rather than actually being able to protect the sort of specifics of the formulation.
Yeah, and then I guess processes as well, and machines. So there's a lot of development in kind of technology in order to extract oils from the plant, and probably better ways to farm it. What's the sort of scope in those areas?
Either of us can say that. Yes, absolutely. Yeah, bog standard. Again, you could see how harvesting methodologies to improve yield, definitely patentable. Bits of kit that help you do that. Bits of kit that help you extract. And there's no issue at all.
Yeah.
And you could see actually how that could give you a commercial advantage across a range of uses of the final product. So just going back down the chain to the plant and then growing and developing that, At scale, you could see how small improvements could help quite a lot.
Yes.
And companies certainly are applying for patents in those areas on the sort of harvesting and processing aspect, and then the kind of analysing and extracting of the cannabinoids. There's certainly a lot of patent applications on that sort of thing.
Yeah, I think in the US, there's some, you can buy these crazy machines that do everything. You sort of cut the plant down and they sift it through and the buds come out at the end, and it's quite incredible. Cool. So then plant genetics is probably one of the more controversial areas. Probably a lot of misconceptions around the fact, because I regularly hear people saying you can't patent the plant.
Yes, it's interesting. So first of all, perhaps taking that question of whether you can patent the plant. In Europe, generally we go for patent protection through the European Patent Office, which is a central office in Munich. And it is, I think, fair to say now that it's very difficult to get a patent to a naturally occurring plant. The Patent Office has actually come under a lot of political pressure from very strong farming lobbies in Europe to not grant patents for plants that are naturally produced. And that's not related to cannabis, but obviously it's relevant. Mm-hmm. And that's because farmers feel that the patent right is too strong in this particular area, and that it restricts the ability to breed further varieties. Mm. And so it's being pushed, the sort of protection of naturally occurring plants is being pushed to the plant variety right.
Which is a separate right.
Which is a separate right, and you apply to a different body for that. And it's not quite as strong as patent protection. There are some exemptions, including a breeder's exemption, so that you're allowed to take the seed and try and grow new varieties. And that's not covered. So it's difficult now to get a patent to a plant. You can get patents to genetically modified plants. That's not excluded.
Right. And is it the same in the US?
In the US, it's slightly different. So they have different types of patents in the US. You have the utility patent that Rob mentioned, also plant patents. But there's also a breeder's exemption on that. So it's a sort of a similar approach.
Yeah. So you could technically have some protection over a specific strain.
Yes.
And that, let's say that that could be your strain that you sell exclusively because you have this protection, but it doesn't stop people from sort of deriving different types of plant off that initial.
Exactly, that's right. And it's quite, plant variety rights are relatively narrow, and they do only protect that particular variety, whereas patents generally sort of provide a broader protection where you can get it.
Right.
So.
Okay, cool. So I think Charlotte's Web, who are probably one of the big famous ones big CBD producers in the US, have patented the Charlotte's Web strain.
Yes, absolutely. Relatively recently, wasn't it? At the end of last year, they got a plant patent to that in the US.
Yeah.
Yes.
Okay. So, and because I think that's a very high CBD yielding plant.
Right. I think, as I understand it, it can often take a huge amount of investment to produce these new useful varieties, and so unless there is some sort of protection for companies in order to recoup some of that investment that they put in, and then there's no incentive to do it if you can't recoup it in some way, or in fact it's just not sort of commercially viable sometimes.
Yeah. So is that delicate balance of sort of encouraging innovation but allowing people to enjoy it without,
and I think that is
ridiculous prices.
Exactly, and that's a really difficult balance. And of course, exactly where the right balance lies, I think, will vary depending on the exact technology that you're talking about. I mean, so if you take one extreme, perhaps, which is a sort of a drug which can cost, millions, you can see that in those cases that you really have to have some strong protection in order to ever do that. But then there are perhaps other situations where it doesn't take quite so much investment, and perhaps the same protection is not appropriate. But we have to have a system that fits, most things.
Yeah, yeah. And getting these sort of protections is commonplace in agriculture, existing agriculture. So it's not like this is a new thing that's happening to cannabis.
No. I think the legal structures that are currently in place will work for all cannabis innovation, more or less. So there won't be any new laws written that will be specific for cannabis. I think there may be some things that we all start to think about more, which come from cannabis, like entourage effects, and how do you then protect something where you want not a single active but a combination of actives in a certain way that naturally occurs in a plant. maybe that's only achievable by defining the cannabis strain and how it's grown under certain conditions, because otherwise, if you did it under different conditions and extracted it, you get a different combination. So there might be things that become quite specific, but then it really depends what you're trying to get as a product and what you're using it for.
Yeah.
So there may be things that come from cannabis, but I think they will slot into normal laws for all of this stuff, and then we'll work out what we can get.
Yeah. I guess the complexity comes from just having the sheer amount of different active compounds within the plant. If you include terpenes and flavonoids, etc., if you've got 300 plus in there, you can tweak one a little bit, and does that make it distinct from another variety that has everything else apart from that one change?
So I think on a variety level, it would potentially.
Right.
But then you would be limited, your protection would be limited to exactly that profile. And so, as you say, it sort of works both ways. If you then tweak it, you can tweak it a little bit more, and then you're outside of the right kind of thing,
Sounds like a minefield. So, sorry, go on.
So as I say, I think, of course, the sort of area of genetics is, I think many people are concerned about it. The idea of, can you patent the plant's genes? It's the same as people were concerned about in the 1980s about, can you patent humans' genes? And with patent law, you have to be both new and inventive. So you have to demonstrate a technical effect over what's known. And so if you take just a sort of a genetic sequence per se, that isn't patentable. You do have to have found some surprising utility for it.
Right.
So when I started in my career, I had to do a patent application on microfiltered coconut milk. Okay, so the idea was that coconut milk, it went off, and if you heat treated it, you lost the flavour. But if you microfiltered it, whatever that meant, then you stopped it going off, but you kept the flavour. So we had a patent on microfiltered coconut milk, and I got phoned up by a Caribbean radio station saying, "Would you like to appear on our show defending how you've patented the coconut, which is known for years?" And I said, well, A, I declined, but B, the point was that isn't what we protected. We protected something that was a development, which was a better form of the coconut milk because it didn't go off and it retained flavour. And that's what happens here. You can't patent stuff that's known. You've got to protect something that's new and that has some sort of technical development in our world. So
yes,
but we have to manage that sort of perception of what are we doing here? Cannabis is known, right?
Yeah.
Well, I think it's an effective misreporting, if you like, or misunderstanding. Often it's a better sensationalist headline if you're saying someone's trying to patent cannabis, which is just vast in its scope, whereas the new development aspect is good.
And so I was going to say, it's probably fair to say as well that there haven't been many cannabis cases in terms of legal cases such as patent disputes, etc. yet. I mean, I think there's one ongoing in the US at the moment. But it is true that I think we don't quite know what the prior art looks like, because it takes a lot of investment, I guess. And so a lot of, in a court case, people have that motivation to go and search through everything that's known and present that in a way that you can actually understand what the prior art is, which is relevant for whether a patent claim is novel and inventive. And we don't quite know what that looks like yet because the cases haven't got that far. Right. So that will be really interesting to see what happens in the US with the current.
And just to clarify, prior art is effectively information around the thing you're trying to patent that is in the public domain.
Exactly. That was in the public domain before you filed your patent application. Right. Yeah, exactly.
Very interesting.
And the States as well, I think there's a move there to really focus on what patent eligible subject matter is. So without getting too dull, things go in waves, and for 5 years everyone focuses on whether it's new or inventive. And now in the States for a few years now, for 5 years now, they've been really concentrating on, is this just something that occurs in nature, or have you done something to transform it into something patentable? And there's quite a lot of discussion around whether things are discoveries or inventions, which may feed into some of this kind of discussion. But again, that's a US specific thing. So we come back to the fact that these will all go in different directions in different countries.
Yes. Makes it all the more fun. Yeah. Cool. And so are there a lot of types of IP that it's a bit crystal ball here, but you think are developing in cannabis that are maybe sort of novel to cannabis, or will it largely follow a lot of characteristics of more established sectors like agriculture?
Yeah, I think it's the latter.
Yeah.
So I don't think we're developing anything particular here. I think it will probably follow the agriculture type system. Yeah, nothing. So that's quite useful in a way because we know the rules and we know actually we can piggyback off that and work out what people have been doing and the kinds of approach they're taking. But I suspect nothing particularly new.
Okay. That makes life a bit easier. And I think we kind of talked about it, but are there any other aspects that you think are controversial at all in this space, other than the plant genetics aspect?
Other than that, I guess I don't really think it's controversial. I mean, there are some, the sort of crossover with what's actually legal. Some has some impact on what rights you can get. I actually don't think it seems to be having much impact in the patent field, but in the trademark area, it is relevant whether the goods and services that you want your trademark to be associated with are legal or not. In the US, clearly it's difficult to get a trademark across the whole of the US for cannabis-related products. And in Europe, there was a case by the main EU court at the end of last year which found that if there was any sort of public perception of associating the mark with illegal cannabis, then that isn't allowed. But other than the real controversy, I think, is around the plant genetics and whether you can get a patent for the plant.
Yeah, that makes sense. And so, following on from that with the plant genetics, how do you view the kind of open source approach? So a few people are doing it. Rob, you mentioned Wellcome Trust before, not cannabis related, but around gene sequencing, was it? Yeah,
they back 10, 15 years ago, they're and the Wellcome Trust purpose is to improve healthcare. They have a kind of charitable series of rules that govern that, and they were putting that information out there with the idea that this is useful stuff that everyone can piggyback off and develop drugs or understand more about human biology. So it's a kind of open source approach.
Yeah,
absolutely. I think, and it's had a massive impact to the field of genomics generally. It's been a huge advantage to medical science. We've been talking about this as to in an ideal world, it would be good to have that in relation to cannabis. It's tricky in that, so for the Wellcome Trust, they're a very well-off charity, and their motivation is just to help promote, health, innovation in science and health, and they don't have to make money back from the things that they support. So that worked very well in that situation. It's more difficult when, as in for most companies, you do need to get a return on your investment. Perhaps also another sort of aspect that's slightly different is, of course, it's many different cannabis strains, so it's not necessarily a case of just providing the genomic sequence of one strain. So it's sort of an ongoing thing. I have been reading about an open source seed initiative going on in the US, which is interesting. I don't think there's any cannabis plants that are part of it yet.
Right.
But it's an interesting idea, and it seems, in some circumstances, perhaps that could work well. But it doesn't address that tension of if it takes you a lot of money to develop a particular strain, can you afford to just give that freely without making any money back?
Yeah, I guess in the other, in other areas like the tech space where what you really want is, my phone to talk to your computer or your phone or whatever, you can't develop stuff that's proprietary. So they ended up, even though everyone filed IP on it, they pooled all the intellectual property into certain patent pools, and then and made those all available for a fee. So that meant that they could all develop their businesses rather than Betamax and VHS going off in different directions or whatever that was. So they could all grow and develop their businesses. They could all talk to each other, and they all got something back from the IP that they developed. So they could
very collaborative.
They can be, and actually then, the other example that I know about was, I think it was HIV medicines, but GSK and others, I think, put a bunch of IP and just said that's publicly available, right? You can get on with that. Public, you can use that. We're not going to split it. We're going to make it freely available. Perhaps it wasn't what they were concentrating on as their first product, but so these sort of arrangements do happen in certain spaces. I think it was either HIV or TB or a big global disease with which those pharma companies are publicly saying, look, we're not trying to make particular profit here, we're just trying to solve this problem. And obviously that's great from a PR perspective as well.
Yes.
But so you either make the materials available, or you can find some clever way of monetizing the IP without locking the whole world.
Yes, so there are collateral benefits, I suppose, as you said, the PR
value. And so will cannabis go the same way? Don't know. Maybe. Maybe.
Yeah, I mean, there are companies, aren't there, in the US, I think, that are publishing some of the genetic.
Yeah.
So, that's only a start.
Yeah, it's a funny one, isn't it? I think with cannabis that, if you're breeding it like a product, or so you're growing it like a product, then you want to maximize your yield of the thing that you're looking for. And it just so happens there might be a lot of different things you're looking for. And can you get that from one strain, or do you need several strains to be able to deliver on those different product lines? CBG, for example, is a precursor to some other of the cannabinoids, and I think it needs to be cultivated or needs to be harvested at an earlier stage before it turns into various other cannabinoids. But are you maximising your yield of a higher value product by doing that? It's all very complicated.
Yeah. Absolutely. So,
but if your market, whatever you're trying to sell it for, needs that, then absolutely you'd be doing that.
Yeah. And
you'd be looking, you'd be analysing it all the way through to work out when your peak is, and and I'm sure there's lots of sophisticated analysis that can be done.
Yeah.
To maximise.
And see if you can maximise, the buds and the seeds and the stalks, so you can monetize all those different parts. So I get there's so much. I mean, I guess if you're a scientist in this area, it must be really fascinating playing around with all these different variables.
Yeah.
Great, cool. So we're coming towards the end, and I probably should have asked this a little bit earlier, but how would a business in this space generally go about protecting itself other than speaking to you guys?
Right. Fair enough. So I think you should just do an audit, start off with, just sit down and go, well, what are we actually doing as a business? What have we thought about? And you can see that being very different. Some businesses will be very techy and have evolved technical solutions. Others won't be techy at all, and will be building a brand around something that that may be really trademark or brand focused. Others will be patent focused. So I think you just sit down and work out what you have to start off with, and then you think you need to work out what business you're in. Are you a consumer business? Are you a medical cannabis business? Are you recreational cannabis? Whatever your business might be, because I think you need to then say what my strategy is. Do I care about IP at all? Yes or no? In terms of my IP, am I going to go after patent protection? What are the costs of that? Is it worth it? Do I care? Actually, I've got a brand business. Don't care about that at all. But I think actually probably the maybe the last point, which is probably relevant for all, is what's everyone else doing? Have they protected their brand, their IP, and am I going to walk all over it? So having a bit of knowledge around what your competitors are up to is actually quite useful,
right?
Which is sometimes where these register databases come in, because we can then say, well, okay, who has been filing on this stuff? We may know who our competitors are. What sort of trademarks and brands are they pursuing for what products? You can get quite a lot of competitive intelligence, and that isn't involving talking to us. You can go and do that online.
So these are public registers.
And they actually give you a lot of information. So that I think knowing your business, at some point you'll ideally want to have a strategy, and people go different ways. Some people don't fire a number of clients who are in the same space, and they do different things for different reasons, and that may depend on your exit as well. So if you think, well, okay, or what you need, you may need investment, in which case you may want to file a patent application because investors love that. You may be looking to build up a business and exit in 3 years, or you may be looking to build up a business forever because it's your dream and you're never going to sell it, and that gives you different time horizons. And all of that plays into what IP strategy am I going to employ?
Right.
So those are super interesting questions.
Yeah, and you were talking about this before we started recording a bit about how patent applications can be used strategically.
Yeah,
for investment purposes and other.
Yeah, I mean, there are patent applications, candidly, where you think that's maybe not the strongest one, or that's super strong, or I know an investor wants to see a patent application, or even I know that a third party with whom I want to collaborate wants to see a patent application. Some companies actually won't talk to you unless you've already filed on your IP, because it makes it very clear what you've done. They may be doing the same thing, of course, and you won't know it. So knowing exactly what you've done, and you've got a registered application in there with a date on it, sometimes helps those conversations and clarifies that when things get valuable, people argue about them. So having some good management, like a stake
in the ground.
Yeah. But knowing who's done what at an early stage can often help difficult conversations later when things go really well. At which point someone says, "Yeah, that was all my idea, wasn't it?" Well, no, actually it wasn't, because look, I filed on it on that date. So yeah, I think just being aware of the commercial value of IP for investment is very important.
Yeah. That's really good advice. So my usual final question is very cannabis specific. You guys aren't working in the cannabis industry per se, but have you encountered any stigma from moving into this area. I've been through the law side of things, so I do know that people can be a bit stuffy. Not always, but
we maybe both have our own experience. I mean, it's always interesting starting a conversation around cannabis because you get the 60 seconds of, dope smoking, stoner,
Marley,
all that sort of stuff. I suppose, and then it evolves quite quickly for us into a serious conversation about big business and protectable rights and important stuff. So it sort of evolves fairly fast. I don't know if Jane, if that's your experience as well.
Not too much. I think as you know, Anuj, my background is been in plants for a long time. It started in potatoes.
Doctor of potatoes.
Exactly, a doctor of potatoes. And so I think with that as my background, people then don't find it, just feel like cannabis is probably a natural progression in terms of
where do you go after that?
Exactly. Exactly.
That's good to see. Yeah, start with potatoes and move on from there. Cool. Well, guys, thank you. This has been really, really useful, and I'm sure it's some very valuable advice to lots of the audience. So thank you for taking the time.
Thanks for having us.
Thank you very much.
Cool. Cheers.